Thank you. Appreciate it.
Thank you.
Okay, fire away if you got questions. If I leave a subject and you still have one, don't mind questions. All right, so the first topic, if you don't have a handout there on the front table there, if you need one, the first thing is the issue of insurance, which is appropriate. That's not, that's just coincidental. What you get and what you don't get when you have workers' comp insurance, remember, first of all, safety audits, you can get OSHA to come in and do a safety audit. Their enforcement division is not allowed to talk to their inspection division when you voluntarily have them come in. So consider whether that's something that you want to do. The Griff's group probably has access to people who can do that also. 1A, the second bullet point, what your insurance generally does not cover, workers' comp insurance does not cover what are called 132A claims or serious and willful claims because they're considered to be intentional acts. So what happens, and we've seen a lot more of these in the last 10 or 15 years, and I'm not a traditional workers' comp lawyer, but I deal with the periphery. Employees coming back to work out of workers' comp, how do we deal with accommodation and disability issues? Or if you get sued on a regular workers' comp claim, whether it's a claim or there's a lawsuit involved with the claim, the employee's attorney will often file what's called a 132A claim under Labor Code Section 132A, which is retaliation. You somehow retaliated by changing their job or firing them or something related to the job. And that's not covered by insurance. And if you get one of those, don't spend $5,000 and hand it to an attorney as a retainer because that's what they want to pursue your claim. 99% of the 132A claims just die. They go away when the underlying claim goes away. So when we see those, we file a little notice of appearance and a request for information, and then whenever there's action, we see stuff. We talk to the underlying defense attorney, and when they go in and settle the case, literally 99% of the time they settle out the 132A and we do nothing on the cases. Serious and willfuls are a little more substantial. Those, again, are not covered by your insurance policies. This would be where you intentionally or recklessly maintained an unsafe work environment. I just finished one with a cleaning crew up in Northern California where a woman had used hot water to get the grease off the floors of the restaurant, except she boiled it in a big pot and the pot flipped over on her legs and badly burned. And the supervisor apparently knew of this practice and said, I want that grease off any way you can, and basically condoned the use of this boiling water in these giant pots, which was an unsafe condition done recklessly. No insurance, and there's a formula for how those are paid out. But those aren't covered by your policy, so don't think that you just hand it over to your work comp. The other one is 1B, Employment Practices Liability Insurance. How many of you know you have EPLI in your company? All right, more hands should go up, and those of you who don't have it, talk to your broker, because EPLI is something your general liability broker will sell, and it's something to look at because it's a safety net. I was up with a restaurant yesterday up north of here, out of this county, and they had just gotten it about 6 months ago, and now they have a claim, and they have a $7,500 deductible. So the typical policy will have $1 million of coverage per occurrence with a deductible somewhere between $5,000 and $50,000. And you may get choice of counsel, maybe not, but that's your coverage. And that's a good safety net when an employee sues you, because now after that first, say, $10,000, if it's a wrongful termination case or discrimination or harassment, failure to accommodate a disability, it just gets turned over to the insurance and they handle it. And it's a good safety net because the average case is somewhere, if we have to go to trial, you're going to spend paying me to defend you, or some lawyer, $150,000 to $200,000 in legal fees. And that's if you win. And you don't get your money back as the employer. It's a very expensive proposition. So the legal fees alone can really eat up one of these policies. And make sure you've got a good policy. I just finished 2 cases for a client who messed up. His policy was $500,000, and it was for all cases within that policy period. And he had 3 of them. And that ate through the whole $500,000 because there were 3 of them and they were bad cases. And he thought he had $500,000 per case, and that wasn't the case. The policy was very clear. So know what you get. The other thing that's important to know about EPLI is what you don't get. There's 2 categories of claims that we generally see. One is what are called the tort claims. Wrongful termination, harassment, discrimination, retaliation, the things that the bread and butter of the cases that we see when an individual employee sues. The other category of cases are the wage and hour cases, meal breaks, rest breaks, overtime, didn't pay minimum wage, screwed up on your piece rates, whatever. Those are typically not covered in that $1 million because they're considered contractual breaches or statutory breaches that are contractually related. So you don't get coverage for that. What you typically get now in the policies that are out there is you get $100,000 of attorney fee coverage. But if there's a judgment or a settlement, the carrier doesn't contribute to that typically. So be careful not to think that when someone comes in and says, well, you didn't pay 4 of us overtime for the last 2 years and it's a $300,000 claim, your carrier is not going to pay that $300,000. They will cover attorney's fees to defend it for a while, but they're not going to pay for the actual loss. That's typical now because of so many losses that occurred on these claims with carriers. So know what you're getting. Also, just some things to make sure that you talk about with your brokers. I had a client a few years ago. They had a $500,000 loss of equipment out of their property down in Santa Fe Springs. Well, the problem was that their broker hadn't done a very good job for them, and that particular location wasn't on their schedule of assets, and employee theft insurance was not one of the coverages because that's usually something extra that you have to ask for. So make sure you know what you're getting and not getting and asking the right questions. The other thing, 1E, tail coverage. That's when you're selling a business or you're buying a business. Are you buying a bunch of liabilities? Have you done a proper audit of the personnel files to see if you've got lingering workers' or wage and hour claims? Have people been misclassified and not been getting overtime that should have? And does their personnel file suggest that? Or do the timesheets show that things are being done wrong? And so there's issues with that in terms of doing an audit, but separately you can buy insurance for certain aspects of the purchase or sale of a business so that you're not tagged with something that maybe lingered from the prior owner, or you're the seller and you want to be done with this, and rather than escrow money, you want to have insurance that may cover these things. So various issues there for insurance. Now, second issue, financial controls. I'm not a CPA by any stretch, but things that have come up over the years. Doing some audit trailing with your employees, even the ones you really trust, and I'll give you a couple of horror stories. I had a court reporting company that I represented, very small, and a 13-year employee who was the number 2 person, the right arm of the owner. And for about 2 or 3 years, she embezzled $190,000. And the way she did it was that checks that would come in for under $2,500, the banks don't audit signatures on the endorsement on the back. It's too low. It's probably higher now. So she would take those checks and she would write them over to, endorse them over to herself, and then she had authority to go into the AR and zero out the AR as if it had been paid. And then she'd cash the check and no one ever found out for a substantial amount of time. $190,000 out the door. Another situation with a purchasing agent for a fairly large company in the county where she and her husband cooked up a scheme to create dummy vendors. And so the vendors would send in invoices and she'd turn them in and they'd get paid. $1 million was stolen from the company. Now they got $500,000 of it back from employee theft insurance, and the other half they got out of their assets. The company aggressively went after them. But little things like that, petty cash in medical offices. If you've got, we had someone at my old law firm where we had someone steal $26,000 worth of vacation from us because she was in charge of keeping track, and she would just load a little bit more onto her check every month as if she were using it, and that didn't get caught because she was taking the piece of paper with her numbers on it out of the 60-page report we got every month. And so $26,000 later, somebody figured it out, and she ended up having big problems. Whoever's opening the bank statement should not be the person writing the checks, and keeping track of those things. So have your CPA, or sometimes consider having a separate CPA come in and do an outside audit. Simple things, little controls that you can put together. Sometimes your existing CPA, while they know your business very well, sometimes it becomes so routine that they don't look at some of the details that maybe they're missing also in terms of things that are sliding under the radar. So consider having just some basic audit procedures put in place. Okay, what else do we have? How about business documents? If you are selling a product, especially if you're in manufacturing. I had a very substantial manufacturer. They do about $40 million a year. And they had a $5 million sale of a commodity to a company in Germany that was having a product made using that small component in this product in France. And the product didn't work. And they blamed it on this widget that my client was selling. The commodity was a computer piece. Well, it turned out that they had asked for the wrong piece. It wasn't the client's fault. They just supplied what they were told to supply. But their purchase order and their terms and conditions, their T's and C's, for a company doing $50 million, and no joke, their entire terms and conditions was one sentence on the back of a purchase order, which was ridiculous. And so if you've got business documents, you need to get a business lawyer to come in and do a tune-up, because there's things related to arbitration, the corporations code in California, the commercial code, all kinds of things that your documents may be outdated, outmoded, not in compliance. If you're doing international work, there's all kinds of issues with that stuff. And I'm no expert, I don't do business law at all, but I've seen it come up in situations where you just shake your head and go, how can a company who's doing 10, 20, $50 million a year in business not have more sophisticated documents? Okay, let's talk about 3E real quickly. If you've got a website, if you've got disclaimers on there, if you've got job openings, if you've got representations about your company or your personnel, go on your website occasionally or have someone that's their job to keep your website up to date. You could have something in there that might come back to bite you because you've got an outdated website. All right, let's talk about arbitration agreements. How many of you have arbitration in place with your employees? Okay, that's not enough hands. 2 things that you can do proactively to protect you against your employees from suing you, or if they do sue you, is employment practices liability insurance, the EPLI that I talked about a minute ago, and arbitration agreements. And the importance of arbitration agreements is that if you get sued by your employee, they are not allowed to go to court in front of a jury. And so it reduces the chances of a runaway verdict, or the jurors not understanding the law, or being swayed by emotion. I would rather have a retired judge who's seen it all and done it all and is not going to be as swayed by emotion and is going to understand the law. I want them trying my case. Plus, we get a date certain. We don't have to hope that there's a courtroom available and the case gets continued for 6 times over a year. That's no fun. And so it's a lot less risk. It's a lot faster to get it resolved. And it's usually much, much cheaper. Even though the law requires that the company pay for the arbitrator, that's still cheaper in the long run because it takes about half the time to do an arbitration as it does a jury trial. And the preparation for a jury trial is a lot more extensive because of we have to kind of spoon feed it to a jury in accordance with the law. It's not that jurors are stupid, it's just that the process requires you to take more time and do certain things. So that $150,000 in legal fees for a jury trial might only cost you $80,000 or $90,000 if it was an arbitration. So less risk, faster, and less expensive. Now, the problem you get sometimes is I see people with homemade arbitration agreements, or they got them from out of state, or it's inside the employee handbook, which is not appropriate. Your handbook is not an agreement. It's something that you can change when you want. So it needs to be separately put together. It has to have the right bells and whistles in it, and I won't go through all those details. But doing things like restricting how long they have to make a claim, or capping the amount of damages they can get, or shifting the attorney's fees, are things that you can't do. Whatever the law allows, if they were in court, you have to allow. There's 2 issues that come up with arbitration agreements. If you have existing employees, they are treated differently than if you have someone who's a new hire. If you come to my business and want to be hired, and I have arbitration in place, and I have 8 attorneys and 13 total people. If you come to work for me, you are given an arbitration agreement as a condition of employment. You must sign this agreement if you want to work in my firm. And as long as I give it to them before they start work, their first day, and they're given notice that they're going to have to sign it, then we're good. If they show up on the first day of work and it's in that big stack of documents they have to fill out, the first day of hire packet, and that's the first time they've seen it, it's too late for them to make an informed decision about whether they want to sign it or not, and it won't be enforceable. So you give them notice. You send it out with the offer letter. You put it in your application that they'll have to sign it, and then you'll be good to go with an applicant for employment, and you can force them. If they don't want to sign it, they don't get to work for you. Existing employees, the law treats a little differently. There, I cannot force you this is all my existing employees. I can't force you to sign, but we have a memo and we issue the agreement, and basically we say, here's a day of vacation if you will sign the agreement. And when we did this at my old firm, we had 45 people that we handed it to, and 43 signed it. And so it's a relatively inexpensive way of getting a safety net in place with the employer to avoid having to be in court in front of a jury, because that's what we don't want. They're too unpredictable. All right, so that's arbitration agreements. I highly recommend that you do it, but then you have to do it right, both substantively, what's in the agreement, and the manner in which you present it. And then don't lose it after it gets signed. And if you've got employees who have access to records, it's interesting how when you've got a more senior employee or, God forbid it's the HR director that you've just fired, somehow their personnel file disappears. And so they should be kept in different places. Hard copies of things like an arbitration agreement or an employment contract or maybe their commission agreement, those could be maintained in hard copy and scanned electronically. Less important things like doctor's note and things, those can be scanned and put in electronic form. You're not required to keep personnel files in hard copy anymore. Okay, number 5, confidentiality, trade secrets, related agreements. I just read an attorney's agreement with his new attorney that he's hiring. And I was surprised because I would have thought an attorney would have known better, but he had a true non-competition agreement. If you leave my firm, you cannot compete against me for 1 year. Well, that's not enforceable in California. Anybody who leaves your company is entitled to go out and compete. They can go to, if they're in sales, they can go to work for your worst nightmare competitor across the street and there's nothing you can do about it. What you can prevent is them from taking your proprietary, confidential, or trade secrets and using them to compete, or just taking them. But for example, there's this nuance in the law that's very important. If an insurance person leaves their brokerage or a lending officer leaves their bank, think of what other contexts, but they're entitled to send out, when I left my firm, we did it pretty cordially because of various things, but I'm entitled to send out an announcement to the clients. So an insurance broker could send out an announcement to their clients. I am now working over here. That's an announcement, that's legal. There's nothing the company can do about it. But if they say, and here's a small difference, but it means a lot in the law, I'm now working over here and I'd love to hear from you, or I will give you a free teeth cleaning that I just read yesterday in a dental agreement, or a dental notice that somebody sent out, a dentist leaving a practice. I'll give you something for it, or please call me, or love to hear from you, or I'll call you next week. That's a solicitation, and solicitations are illegal. So if a salesperson leaves your manufacturing or your agriculture and they go out and compete with your brokers or your vendors, and they are using your proprietary information, even if it's in their head, you may be able to prevent them from using that proprietary information or those trade secrets, but you also have to do a good job of protecting that information. So when you go to court and scream and trying to get an injunction, they can't use my stuff, they're out there competing, look at all the terrible stuff they've done, the court's first question is going to be, well, wait a second, what have you done to protect this information and to keep it as a trade secret, to keep it confidential? So I had a situation with a manufacturer where they had schematics that were very proprietary, but they were left out all over the shop floor. And so vendors could walk through and other customers could walk through and they could see all this stuff. And anybody could go into the electronic system and access this stuff. And anybody could print it off. And it had no notices on it that it was confidential. And the court said, well, you haven't done a good enough job to convince me that this stuff is really a trade secret, because look at all the ways you let it out there for anybody to get to. And so the court said, no, we're not going to give you the injunction. So protecting this stuff and then making sure that when somebody leaves, do you have appropriate protections in place? And we'll talk a little bit about when people leave in a minute. Okay, you also can't put in an agreement, you can't compete against me within a geographic region or for 2 years. That's not enforceable under California law. And putting it in there and saying, well, I'm really not going to enforce it, I just want to scare them, that in itself is a violation of California law, and you can be sued for that. One thing you have to be careful of is that if you hire someone from out of state, or you've got a rep or a salesperson in another state, they may be coming from another company or a competitor, and if it's in, say, Georgia, that's a state that would enforce a true non-competition agreement. So you have to take a look and see what is the agreement that this new hire is subject to make sure that there isn't something in there that restricts me from letting them be my Southwest or Southeast United States territory rep, because they do have a competition agreement in there that's enforceable. So be careful about that. The other thing that's really important when you hire someone in a sales capacity or has had access to confidential information is making sure that they don't take something with them. I had a client who raided, and fairly so, raided a competitor's sales force and took 9 people. And this was a huge competitor. Our person was more of a regional player in his field. And we took these people, we read them the Riot Act, we gave them a memo that they had to sign that basically gave a blood oath that said, you shall not take anything from your prior employer. We don't want you to take anything. We don't need it. Don't download, don't print, don't zip drive, don't do anything. And of course, two guys thought they were smarter than everybody else, and they downloaded some stuff. And they claimed, well, it was a mistake, or we didn't really need it, or we didn't really use it. But the company had done a forensics analysis of all the people's computers when they left, and they found that these two guys had zip drive stuff 3 days before they left. And it was things that they wouldn't normally have zip drived. And that cost the client over $2 million in settlement and legal fees because these two guys were idiots and they didn't follow what was going on. So it's important that you impress upon people not to do stuff and you back it up with some follow-up to make sure. And then if somebody does leave and it's someone that you think might be a problem, we send a letter to their new employer, to them saying, hey, we're watching, and if we think you're competing unfairly, we'll consider our legal rights. Or save their hard drive, or do a forensics analysis of their hard drive to see if they took anything that looks odd right before they left. We just finished a case with a woman who had taken a list of clients the day that she was told she was going to have to change the way she ran her practice or her sales function, and she didn't like that. So she took all the clients on a list and left the next day, or knew she was about to get fired. And that created a huge lawsuit and came out favorably to us because we were able to show that she took something improperly. Okay, let's move on to number 6. This is always a hot issue in employment law. This concept of exempt versus non-exempt employees. Exempt people are your salaried people typically who do not get overtime. Supervisors, managers, people in the C-suite, the CEO, COO, the chief knowledge officer, and some of these goofy names that I love seeing on some of my clients. The startups always have some crazy thing. So if I just insulted a chief knowledge officer, I apologize. But sometimes there's a gray area. I got a call yesterday from a manufacturer down in Los Angeles. They said, we have a purchasing agent who is exempt, salaried, and they're going to be going to China, and they want overtime for the 2 days out of the weekend when they're going to be sitting over in China. Do we have to pay that? And I said, well, let's take a step back. Is this purchasing agent really exempt and should be on a salary? And they said, well, we converted her to salary a couple of years ago because it was too much trouble to keep track of her hours. Well, that's not really a very good excuse for moving someone over. And the federal law allows purchasing agents in certain circumstances to be exempt from overtime. One fundamental thing you always have to remember when you're looking at wage and hour law, whether it's overtime or classification of exempt or non-exempt or meal breaks and all that stuff, federal law and state law differ. And you are subject to both in California. And whichever law most favors the employee, you have to follow. So the 8-hour workday, overtime after 8 or an ag overtime after 10, there's no federal law that corresponds to this. Now, agriculture is exempt under federal law in many ways, so it's not the best example. But overtime after 8, there's no federal law. Meal and rest break penalties, there's no federal law. Travel time, treated very differently. Federal law says that if you travel for the company, and this is for non-exempt people, if you travel on non-work time, like at night or on the weekends, at night, then you don't get paid because you're not on regular work hours. But state law says differently. State law says when you travel, we don't care whether it's 5 o'clock or 10 o'clock at night or 7 o'clock in the morning, you get paid if you're non-exempt. So federal law is irrelevant. Or this concept of comp time. You work 6 hours extra this week, we'll put 9 hours in a comp time bank, time and a half. Well, California has this nice statute that allows for that. That's great. Except federal law says you can't do that for non-exempt employees in the private sector. Not allowed. No comp time. So you always have to make sure. And the client yesterday says, well, I was reading this stuff from the Department of Labor website. And I said, well, stop. That's federal. Let's talk about what California allows. So back to the purchasing agent. And this happens a lot in companies where you've got, think of your workforce as a pyramid. You've got the people at the top who are clearly exempt, directors, well, director level, or vice presidents, senior managers, CEO, C-suite folks. And then you've got the bottom of the pyramid, which is all your production people that are almost always hourly. But then there's a band of people in the middle, purchasing agent, accounting people, HR people, sometimes project managers, depending on what they do, IT people, big problem area. Those are people who often get a salary because they're seen as more senior, or they make a decent amount of money that looks like they should be exempt, or the nature of their work is hard to track, like IT. I've had clients say, well, you know, they're doing backup at 2 o'clock in the morning or restarting our IT system. I can't track their time. We made them exempt. Well, that's not necessarily allowed. And so here's the test that trips people up, because the analysis of who's exempt and who's not is different from state law to federal law. Federal law says if your predominant duty is management, for example, you're exempt. Well, what's predominant duty? Well, that's not really defined heavily in federal law. But California has a bright line test. 50% of their time has to be exempt. And now let me give the illustration I like to use. I go to Starbucks every morning. If you live in Camarillo or ever in there, and you want to find me between 5:30 and 8 o'clock, 7 days a week, you'll see me at the Starbucks by the California Grill or Ralph's Market. I'm pretty easy to find. And they moved my space about 2 years ago. I'm now the bathroom monitor, which just about kills me, but oh well, I can always tell who's not washing their hands because it's got a blower inside the door right behind me. Yeah, it's great. Okay, so the Starbucks coffee store manager manages people, hires and fires, budgets, does all the things that a manager does. And under federal law, their predominant duty is management, so they're good to go. They're exempt, they're salaried, everything's great. Except about 7 years ago, the Starbucks store managers filed a class action, and ultimately Starbucks paid $15 million to their California store managers because they didn't meet the bright line 50% test. If you go into a Starbucks, what does the manager do more than 50% of the time? Pours coffee, cleans up, changes light bulbs, straightens the shelves. That's all non-exempt work. And so now Starbucks store managers only in California are paid on an hourly basis for their 44 or 48-hour work week. And they get overtime because they are not exempt under that test. You take someone in a 3-person accounting department. And by the way, you probably are starting to get indigestion and start to squirm about people in your offices or somebody who's sitting here. I got chewed out by a doctor once who said, "Why did you tell my office manager all this stuff? Now she's telling me she's non-exempt." Well, this was a physicians only meeting and you sent her, not my fault. But the problem is, for example, that 3-person accounting department, AP, AR, payroll, they're pushing paper, that senior person who supervises those other 2, and that's part of the criteria. They supervise 2 people, great. But it's real easy to say, you and you go do this, and I'm going to go do this, and we're all doing the paperwork, or we're cramming out payroll at the end of the 2 weeks, or we're doing the month end. And that accounting manager is spending more than 50% of his or her time doing non-exempt tasks. They don't qualify as exempt. And the problem is that everybody's happy with their exempt salaried status until they're not. They like being autonomous. They don't have to have their work micromanaged. They can show up a few minutes late. Nobody cares. They can leave a little early because they're working a lot of hours. But if something goes wrong, or they don't like their new supervisor, or now we have, they've had some issues with personal life and they're not as good an employee as they used to be, or they're slowing down in their work and you want to do something about it and then you terminate, well, now they go to the Labor Commission or they get a lawyer and they will dumb down their job and say, well, I wasn't in charge of all that much and I really didn't spend that much time supervising, and most of the work, more than 50% of the work I did was non-exempt. I want my $50,000 of overtime. And it adds up. I had a McDonald's franchisee several years ago where all the assistant managers were paid a salary. This was in the 90s, before this really was a huge, huge issue. And we convinced them to move them all over to non-exempt hourly status because we were able to show them that with 27 assistant managers at 4 hours of overtime a week times 4 years, plus attorney's fees and costs and interest and penalties, was about an $800,000 liability. And that got the client's attention. And they switched him over. And about 6 months later, McDonald's corporate paid $19 million for the very same claims, and my guy never got hit. And then the switchover is always difficult. You say, all right, smart guy, you've told me we screwed up our classifications, and now we need to switch them from exempt to non-exempt. How do we do that without getting sued? Well, that's not always easy. And because now employees say, well, why am I suddenly getting overtime? Why is that different from 3 years ago? And we have some strategies for dealing with that issue, but it's not a perfect scenario. But the problem is you have a rolling liability as long as that person is paid a salary, working overtime, and may not reach the 50% test. So that middle band of workers is where you need to analyze your workforce and see whether you have any problem people. Okay, so back to number 6, see if there's anything else I want to cover there. And it's a 4-year liability, 3 years under the Labor Code. And then there's a statute called Business and Professions Code Section 17200. It's an unfair business practice to underpay your people. And that gets a 4th year onto the claim. All right, what else? Working supervisors, I see this in construction all the time where you've got a field supervisor who's out there and he's got a crew, but he's more of a lead person. And for whatever reason, he's paid a salary. Well, that's not going to cut it because they are saying, you and you go do this and I'm going to go do this with you, and they're only spending 10% of their time supervising. Not going to happen. All right, let's move on to number 7, the wage and hour liability. No.
Outside salespeople?
Oh, let's talk about that.
Can you just explain?
Yeah, salespeople. There's 2 categories, outside and inside. Okay? Outside salespeople are completely exempt from all this stuff. You don't even have to pay the minimum wage because it's the nature of the outside salesperson exemption. They could be paid piece rate, they could be paid commission, they could be paid hourly, they could be paid salary, bonuses, whatever you want. It doesn't matter if they qualify as an outside salesperson. Now, what's an outside salesperson? They must spend more than 50% of their time away from a fixed location. The office or their home counts. And then when they're out there, they have to be selling or doing something very close to selling, like pharmaceutical reps who are promoting product. The courts have said they're salespersons under this exemption. Where you get a problem is when they have mixed duties. I represent a lot of pest control companies, and I've had major arguments with the client. They say, it says right here in the federal law that outside salespersons are exempt, and my guy sells. Yeah, but your guy's spraying pest control, or spraying pesticides, and as a small part of his business, he upsells their products when they're out there at the site. 5% of their time, 10% of their time. Or there was a famous case we had, Yosemite water delivery guys, like the Sparklets guy. They would upsell the Sparklets products when they were in the home or at the business. And Yosemite didn't pay them overtime because they considered them to be outside salespersons because when they delivered water, they sold a little bit. And the court said, no, not happening. Are they spending more than half their time selling versus spraying pesticide or delivering water? So you have to be careful that they're not doing something else because they're a route person and they happen to do some selling. Does that help?
Can I ask one more question?
Sure.
If I have an outside salesperson and I currently have them hourly.
This is just a hypothetical. You have a friend.
Of course, I have a friend. If this friend, how do I get them to comply with punching in and out for lunch?
Well, are they an outside salesperson? Not subject to that stuff. Inside salespeople are. Now, here's another little problem. How many of you have some sort of inside salespersons? Okay. Here's the problem with inside salespeople. Unless you are engaged in a retail operation, you probably do not get to keep your inside salespeople from getting overtime. Here's the problem. Let's say you're a manufacturer and you have inside salespeople. Even if they're on commission, that commission is subject to overtime calculations. And the inside salesperson, if they work overtime to create those commissions in manufacturing, you must pay them overtime. And you have to take their hourly rate and the commission and lump it together for that pay period and then calculate the overtime based on how many hours. There's a formula, I won't bore you with that. There's an exemption for inside salespeople, but you have to be in a retail operation. And here's another state-federal problem. State law says if you're a wholesaler or a retailer and you have inside salespeople, those people are exempt from overtime if more than half their compensation is commission. That's critical. And the problem usually is they get a $4,000 base and $2,000 of commission in a month. That doesn't satisfy the test because it doesn't go over 50% of their income. Or they're on an hourly rate and their commissions don't go over 50% of their total income. They're not subject to the exemption. But you have to be, in California, wholesaler or retailer. But then we have a little problem because federal law says you got to be a retailer. They don't allow wholesalers to be inside sales exempt. So there's a very narrow group of you that have inside salespeople who may be on commission who are exempt from overtime. So if you're not in that category and you have inside salespeople and they're making a $4,000 base and they're getting $2,000 of commissions in that month, and they work overtime to achieve it, even though they're on salary and commission, you now have to calculate overtime based on that $6,000 they made. So that could get ugly. So either keep the overtime down or start paying it. That's going to be the problem. Okay, now have I answered all your questions? Your friend will be pleased? Okay, yes?
When would a salaried employee be eligible for overtime?
When would a salaried employee be eligible for overtime? There's two tests. It's the nature of your work and it's the nature of your pay. You must be paid a salary to be exempt, and you also need to be in a job that qualifies you as exempt. So you could have salaried non-exempt people. I could pay my receptionist a salary. If she works overtime, I have to pay her because the nature of her work does not qualify as exempt. So that would be the simple example. And I had a guy in Bakersfield one year say, well, I've got 26 employees. We don't bother with overtime. I just pay everybody a salary. Well, that's a problem when you have a janitor or a receptionist or you have someone who's otherwise non-exempt. Just putting them on salary does not solve your problem. And then it gets ugly because if they're working 50 hours a week and they're making $1,000, that $1,000 has only paid for 40 hours if you misclassify them. That extra 10 hours, if you've paid zero. You don't just owe the half-time premium for overtime on that extra 10 hours. You owe time and a half. And that gets expensive. Another place where federal and state law differ. All right, what else can I do to brighten your day? Any other questions? Okay. Let's talk about meals and rest breaks. Hot issue, big deal. I just read some stuff this morning, agricultural client. They're on piece rate because of the nature of the product that they're harvesting. And they've got something going on where employees are claiming that the piece rate does not count their exercise in the morning, doesn't count traveling from one block to another, doesn't count tailgate meetings. That's not in the piece. We haven't been paid for those things. You violated minimum wage. That's the claim somebody's asserting. Well, you have to specifically, you can have piece rate for any kinds of employees, but you've got to define what the piece is. So for example, I represent a lot of home health care agencies. And so a caregiver will go out to a home, do an assessment, take care of the person, and then they have to write up a little report, and they turn it in. So there's three pieces that we've defined. You get $70 or whatever the number is. Let's say $70 for the piece. And the piece includes travel to and from the site, the visit, and the paperwork that you do on your computer when you get home or back to the office or in your car or whatever. Those are the pieces. And so as long as you clearly define what they are, then you're safe. Now, they still have to pay travel time. The mileage that goes into these travel from after the first site and then coming home from the last site or up to the last site, you got to pay all that travel in between. So if you've got someone driving their own car, I have someone in ag who's got an HR person that goes from site to site, does little trainings, sees how people are doing on their work comp, if they're working. And the travel in between sites, because they're driving their own car, has to be compensated. The IRS rate, 56.5 cents a mile. You can go below the IRS rate, but don't go too low because they could make a claim that that's not sufficient to reimburse them. And I had a client yesterday going, well, travel time seems to be a perk to me. Why do I have to pay that? No, it's not a perk. It's time that you must pay. But keep in mind, when someone is on travel time, you may pay them at minimum wage. So like this person who's going to China that they think they're going to convert back to hourly, we can say, well, you make $20 an hour when you're working, your regular work, but when you're traveling, we're going to pay you at $8 an hour. And you can have different rates for different kinds of work. That's okay. Where it gets a little complicated is when there's overtime, you have to blend the rates. I won't bore you with how, but you blend the rates to come up with a blended rate overtime component. Very common, like I've got contractors who have crews going out to Santa Barbara or the Valley or somewhere distant. They're getting $8 an hour for their travel, and they're getting their $15 an hour for the work they actually do. But at the beginning of the day, they travel an hour, and at the end of the day, they travel an hour, and they work 8. That's a 10-hour day. Well, just because the last hour is at $8 an hour doesn't mean you pay that at 12. You blend the rates based on how many hours at each rate, and it might turn out to be $13.40 an hour. And now you pay the halftime on that, which would be $6.80 or whatever that is. So there's formulas for this stuff. It's not hard ultimately once you do it, but you've got to remember when you're doing things with travel time or some of these other issues, you've got things that you may forget about. You owe the mileage, even if they're deadheading. Or you've got crews that stop at a yard and pick up a bunch of supplies and then drive to the site. If that person lifts a bag of fertilizer or a hoe or whatever when they get to the yard, and they're not just there to deadhead out to the site, as a courtesy. You say, well, we'll supply a van if you want to join us. Otherwise, you can drive yourself. If it's voluntary and you show up and you get in the van and drive, we don't have to pay you for deadheading out to the site. But if you come to the yard and do a little bit of work and then get in the van and drive to the site, we owe you from yard to site and from site back to the yard. So it's critical if you are accommodating employees by saying you can travel with the group or with a designated driver who we're paying. We're not going to pay you. So when you come to the yard, drink coffee, and eat a donut, but do not do any work. Then you're okay. But be careful, especially in construction. That can be a problem when someone comes to the yard and starts doing some work.
Question.
Yeah.
In that scenario, the person driving the company vehicle, do they need to be paid?
Yes, absolutely.
But the passengers do not.
Correct. Now, if you're giving them a company vehicle that they can take home and that's their transportation, then it's a little different. But there's also some special rules about the distance of travel. If it's within a regular commute time, for example, I've got a roofing contractor. Actually, it's different. I think they're asphalt contractors, or they are asphalt. We have created their usual location is Ventura County. If you are traveling into anywhere inside of Ventura County as an employee, we're not paying you. That's our normal commute time. Once we have a job in Goleta or the Valley, you will be paid from the county line out, and we calculate what the distance and what that time should be. And they're actually paid that at minimum wage because unusual travel beyond a normal commute has to be compensated. Or people traveling from site to site during their workday has to be compensated. Okay? I get it? All right. Let's now get to meals and rest breaks. We had this big change. How many of you heard of this case called Brinker? Okay, well, Brinker was the hottest issue in employment law in California in the last 10 or 20 years. It basically changed the way we deal with meal breaks pretty significantly. Meal breaks and rest breaks historically were treated differently. I have to force you to take your meal. It's got to be a half an hour, and it must start before you end your 5th hour. If your day starts at 7 a.m., you got to be eating by noon, or it's a violation. You get a full half hour. If we shorten it, it's a violation. And the penalty is an hour of pay for every day that you mess that up. You skip it, you shorten it, you delay it. The burden was on the employer to make employees take their meals. In contrast, rest breaks are treated differently. You get your 10 minutes, each 4-hour block. We offer it. If you choose not to take it, we don't have to make you take it. Now keep in mind, this whole discussion of meal and rest breaks is only for non-exempt employees. Salaried exempt, none of this applies. And the penalty for not letting someone take their meal or not making them take it, and the penalty for not getting one of their 2 rest breaks was an hour of pay. Separate obligations. You could have 2 hours in a day violation. And it's an hour of their pay at their rate. Okay. Then Brinker came along in April last year, and Brinker said, game changer, you no longer have to force employees to take their meals. This was in the restaurant business. They want to skip their meals so they can keep getting their tips during the busy time. Fine. Where that creates problems for you all is you still want employees to take their meals for 2 reasons. And we have in our policies now, we say to get them to take it, you can't skip your meal to create overtime, and you can't skip your meal to leave early. So that basically forces employees to take their meal because they have a set schedule. And you can't leave early at 4 o'clock now, 8 to 5 day. And you can't work through to suddenly create an 8.5-hour workday. And that pretty much forces employees to take meals. And we have in there, if you are having trouble taking a meal, we want to know about it. Because then we want to work with you on your schedule. Because we don't want you coming back later and saying, oh, I couldn't take my meal, I was forced to. I had a pediatrician's office where they had a problem because they said, well, you get your rest breaks when whenever you want. Mornings, no problem. But in a pediatrician's office, what happens at 3 o'clock? Overrun with children, and there was no time to take a rest break, and everybody knew it, and they never took them. And so we had an institutional problem in that office, and we ended up paying some penalties. So you need to regulate. Now, I had an ag client who did a phenomenal job of documenting rest breaks, which isn't required, and meal breaks, and then the second rest break, and they have the field, like those credit card things that you do remotely. They have a swipe that all the employees would do, and it kept great track of everything that went on in that field. And so we were able to prove that employees got their 30-minute meal break and got their 10-minute rest breaks because they swiped then too, which you don't have to do and was unusual, and I didn't expect to see that. But it was wonderful. If you're going to have people record rest breaks, though, you need to be on top of it because I had a McDonald's franchisee that did that, and 90% of the breaks were not recorded because they just forget. They were getting them because it's a very controlled environment, but the paperwork was bad because there were so many misses. So be very careful about documenting rest breaks. It's not required. It tends to get forgotten. And you don't want a record of forgetting. Now you have to prove that they really got it, and it's a hassle. Here's another little thing that comes up. That exempt employee who now claims they were really an hourly non-exempt and should have been paid overtime, and they go to the Labor Commission. And you say, well, how can they prove their case? They didn't keep time records because we treated them as exempt. There's no paperwork to support their claim. Law says the burden's on the employer to keep track. And in the absence of written records in an indelible form, the employee is entitled to testify about their recollection of when they worked. I normally worked 9 to 6. Well, unless you've got 6 employees to say, oh, no, they left with me at 5 o'clock, that's enough if it persuades the Labor Commission or the court. So the employee's recollection can be enough. All right. Now, Brinker, yes.
I have a question.
All right.
My friend
Yes.
has an employee that goes in,
Well, that was the first mistake.
goes into work at 4:30 in the morning,
Okay.
and the rest of the crew starts a little bit later.
So, but they like to eat lunch with their friends.
That's right.
And the truck doesn't come till 11 o'clock, or let's see, 10:30. Okay, so they're at 6 hours now, and everybody else is within 5.
Correct.
Okay, it's voluntary. So what I would do with that person, this happens all the time in ag, where they're, in the summertime I have country clubs I represent, and the grease crews normally start at 6 in the winter, but they start at 5 or 5:30 in the summer, and they don't eat lunch till noon. Well, that's, or whatever that works out to, 11:30. It's more than 5 hours in the summer. And so they've gotten burned. For that person, I would have them sign something that says, we understand that you like to take your meals late. This acknowledged, by signing below, you acknowledge that you're doing this voluntarily, that we're not requiring you to. Normally your meal would be before 9:30. It's your choice, and anytime you want to take it early, you're free to, but please acknowledge that you're wanting to do this later, or whatever words to that effect. Just have them sign something. Or someone who regularly works 6 hours, we used to have them sign, and you still could, that whenever I work a certain number of hours, I'm waiving my meal, but if I ever want to take it, I will. If you do meal break waivers, there has to be an on-duty meal break waiver. Sometimes say, well, we'll just have them sign an on-duty one. That's not enforceable unless the nature of the work requires it. So for example, I've got dermatologists who do these Mohs procedures, and they're never sure how long it's going to take because they keep scraping skin until they find no more cancer. Well, if it keeps going, it takes longer. And it runs into the lunch hour for the tech or the nurse. And they've signed something that says, I understand on those days when we run late, I waive my right to my 30-minute meals within 5 hours. I'll take it later. That should protect us because the nature of the work requires it. But don't do a homemade one because it also has to say at the bottom, or it's not enforceable, I understand that I can revoke this waiver at any time. And without that, it's not enforceable. I've got a class action up at the Supreme Court that 4,000 security guards who did sign the waivers, but they're saying, well, even with single guard sites, they should have been able to take a meal off duty. Not possible. And we're fighting about that, but we have the waiver in place that gets us halfway there. One other thing with rest breaks that the Brinker case made clear is you get a 10-minute break in each 4-hour block of time. That's clear. Everybody pretty much knows that. But what if you work 10 hours and 15 minutes? And what's forgotten and what Brinker made clear is that it's not only 4 hours you get 10 minutes, but you get 10 minutes for any major fraction of 4 hours, which basically means more than 2 hours. So if somebody works 10 hours and 15 minutes, there's a 4, and there's a 2 hour and 15. And that third increment of 2 hours and 15 minutes creates an obligation to be given another 10-minute rest break. And if they work over 10 hours, they're also entitled to take a second meal break. Now, nobody ever does that, but they're entitled to. So you need to make it clear to employees that if they work over 10 hours, they're entitled to take a 30-minute rest break, or meal break. They won't be paid, and nobody's going to do it, but make it clear that they can do it if they want to. The waiver of that second meal does not have to be in writing. You might want to do that as a little safety net, but it's not required. But don't forget that third rest break. And again, employees may not bother taking it. They want to just go, but they're paid for it. But make it clear in writing. And so we've modified our meal and rest break sections in our handbooks because we want to make that clear. And we always put the burden back on the employee. If you are having trouble taking your meals or your rest breaks, you let your supervisor or HR or somebody in management know so we can work on your schedule. Put the burden on the employee. We do that a lot with 2-day, 3-day no-show, no-call. You weren't here, we don't know where you are, or you're terminated, or if it's some situation where maybe there's something odd going on. If there's something about this situation we're not aware of, please let us know. Because I had a motorcyclist about 20 years ago now probably that sort of drove this point home. 3-day no-show, no-call, terminated. And there were some other things that put him in kind of a special category, I forget why. And about 2 months later, he calls and says, well, he sued the company for some sort of discrimination. And in part of it was that they fired him when he was out. And we said, well, where were you? He goes, well, I was in a coma. I was in a motorcycle accident. Well, that's a pretty good reason why you didn't call. Why didn't you call us after we sent you the termination letter? Well, because the letter seemed so final that I didn't think it would do any good. Because it basically said, no show, no call, you're fired. So giving the employee the opportunity to come back and give us some explanation. Or in a disability context, we've evaluated the job description, we've worked with you, we just don't see how we can accommodate this job. But if you think we've missed something or you want to discuss this further, please let us know. Always put the burden back on the employee and give them the opportunity to tie that last knot if they want to. And if they don't, you look good because you made an effort. Okay, 7C, we talked about comp time. You can't do it in California. You can do what's called make-up time. If you have an office environment or an environment that's conducive to this, the employee can say, within the same work week, and that's critical, so you don't go over 40 hours, I want to take 3 hours off. My office manager, if she were, well, she is hourly. She's taken off today at 4 o'clock to watch her daughter play basketball. She's a big stud player at Rio Mesa. And she, if this were the case, she could then work the extra 2 hours or hour tomorrow and go over 8 hours, but I wouldn't have to pay overtime because she got make-up time. And if I approve it in advance, 2 hours off today to work 2 extra hours tomorrow, I don't have to pay the overtime. But it has to be in writing and approved in advance. And it can't slop over to the next week. I want to take the hours off today, I'll work them extra next week. Not allowed because next week she'll then work 42 hours. Can't do it. And there's some other little restrictions, but make-up time can work depending on your work environment.
Question.
Yes?
If they work more than 8 hours earlier in the week, and then wanted to use that make-up time on Friday to take off early.
Sure.
So
But it has to be negotiated in advance.
So you know they're going to have to, it's going to go into OT as long as it's,
It could be in any order.
okay.
The key, though, I should have mentioned this, is that the time off has to be for the employee's benefit and at their request. It can't be, boy, you worked really hard today, I need you for 10 hours today, why don't you take 2 hours off tomorrow? That's not make-up time because you forced it as the employer or you suggested it. Now, the other thing, your safety net is you never have to approve it if you don't want to. So if it doesn't work for you as a business on that particular week or instance, you don't have to do it. Or you can do it on a recurring basis. I need to take 2 hours off every Wednesday to go to a class, and I'll work 2 extra hours on Thursday. They can sign off for that for the duration of the class, for example. So that might work.
And you let them know that it's a possibility if they do work in a situation that they are able to.
Have to be careful about that because it has to be at their request, usually driven by something that they want the time off for. And so we have to be really careful because you could do it and it may look fine and then sometime later they make a claim. Again, they're happy till they're not. And now they dredge that up and go, well, it was really at the company's benefit, for the company's benefit. And then we have a problem. So that's a tougher call. All right, let's talk about vacation and sick time or PTO. Paid time off, PTO, where you lump it all together. How many of you do PTO? How many of you have separate vacation and sick time? How many of you have vacation and no sick time? Okay. Be careful with vacation, no sick time, at least for your exempts. If you've got an exempt employee who's kind of working you and they're taking a lot of time off, if you have no sick time policy in place, even a day or two would be a good idea for exempts. Once they exhaust it and you think they're working you a little bit, you may deduct their pay for the full days that they miss. So I have a client down in LA where we did this, where we added 2 days of sick time just for exempts so that if someone exhausted the 2 days and then they were kind of working us, we thought, we just deducted from their pay, which is totally legal once you have the policy in place and they've used it up or they didn't qualify for it yet. Okay, I don't have a strong preference for PTO versus vacation and sick. The only benefit is for sick time and vacation separated, the sick time can be use it or lose it. You accrue 5 days a year. It caps out at 10, for example, or 5. It doesn't matter. And if you leave, you don't get it. That's okay because it's not a wage. It's a benefit. Vacation treated separately. Vacation is a wage. Don't ask me why the distinction. And it's like wages. So when they leave, you got to pay it, and you can't forfeit it. Once they earn it, it can't be forfeited. If you cap the amount, you get 10 days a year, 80 hours. If the cap is something less than 1.5 times that, so you can accrue up to 15 days, 120 hours. That's legal. But if the cap is 80 and you get 80 a year, that's too low. And if you bump up against that cap, they should be able to go farther. So make sure your cap's not artificially low. I like to do it as a percentage or a ratio. It's 1.5 times your annual or 2 times your annual. If you cap it at 4 weeks, well, that's great for the people getting 5 days or 10 days a year, but what about someone getting 15 days a year? They need 22.5. It's not enough. So do it as a percentage. Also, I see this a lot. Page 5 says, introductory employees do not get any benefits during their first 90 days. Well, they don't get vacation accrual. Great. 20 pages later, I see a vacation policy that says you earn 80 hours in your first year, or 40 hours in your first year, 80 hours in your second year. Well, if they get blown out at 2 months and don't make it, you owe them 2/12 of that 40 hours. You can't wait for the end of the year and then boom, it's all conferred on them at once and vested. Or it doesn't vest till 90 days. No. It is accruing on a daily basis according to California law. And if you truly do set it up as you don't accrue anything until the 91st day and we start then, it kind of penalizes your good employees who make it through the first year. Because at the end of the year, if they're supposed to get 80 hours, they've only got 60 hours. And you can't load it all into the back 9 months. The law doesn't allow that. So be careful about having inconsistent policies about what they earn in their first 90 days. What else? Paid time off is fine if you want to lump them together. Just remember that it all gets paid off. I had this problem yesterday. I have a client somebody went to the Labor Commission claiming they didn't get their vacation when they were fired after 7 months. Her policy is very clear on the vacation that she really does not start earning until year 2. And I think we will win on that. The problem is, and which hasn't been discussed yet at the Labor Commission and is not in the claim, and the employee probably doesn't realize this, is that there's also a personal days section. You get 3 personal days a year. Well, that's just like vacation. My client was thinking that that would be used for sick time, but it doesn't say that. She could take it off for anything. So it's PTO. That's vacation. It can't be forfeited and was earned pro rata for those 7 months. So we owe her about 2 days of this PTO. And the problem is that 2 days of PTO is not a lot of money. But there's also something called a waiting time penalty under the Labor Code that if you don't pay all wages due at termination, which those 2 days would be, you owe a month's pay, 30 days pay. And that's, for this woman, will be $40,000, $50,000. All because of those 2 days are sitting there. Now, they haven't figured that out yet. We'll see. It doesn't seem fair, but that's an issue. So be very careful. When you terminate someone, you owe them all their wages on the day you terminate. You can't wait for the direct deposit to hit. You've got to pay them on that day. Or you owe them a day of pay for every 30 days that goes by for any portion of the wages that you didn't pay. If they resign, you've got 72 hours, and weekends count. You must pay. Also, make sure to stop that direct deposit. I've had a couple of double payments to employees that, good luck getting that back.
Quick question on that. If someone quits or walks out or whatever, as an employer, how long do you have to pay them?
72 hours.
Okay, so same.
Yeah, same thing. And this gets a little tricky. If they don't come and pick up their check and you don't normally mail it to them, don't mail it to them. You write them a letter saying, I have your final check. It was ready on the day you left, or 3 days later. Where would you like us to send it? Or do you want to pick it up? Or what? Because you're technically not supposed to mail it. And if 6 months go by and they never got their check, then you send it to the Labor Commission. And this is a problem sometimes. I understand, and this would be in agriculture a lot, the workers sometimes don't cash their checks. They just sit like it's a savings account. And a little bit tricky in that situation. What do you do with that check when now it's stale? Well, let it sit there, or you send the money to the state and it's their problem. There's a way to do that. Okay, remember that if you have a sick time policy, you have to allow employees under state law to spend at least 50% of that time to take care of family members. I like to say just let it all be used for family members, because do you really want to track the nature of how they use their sick time? It's a big pain. If you're paying piece rate, or a daily rate, this happens in construction jobs. I'll pay you, $300 a day for this roofing contract. Well, if they work overtime, over 8 hours to do it, you've now got to pay overtime on that piece rate or that daily rate. Bonuses. How many of you do some sort of bonuses for your employees? Okay, here's the deal. There's discretionary and there's non-discretionary bonuses. We're not going to get through the whole agenda, so don't panic here. Discretionary bonuses are, hey, it's holiday time, here's $500. I don't have to do this, even though it's expected every year to get one. I don't have to. That's a discretionary bonus. We had a great quarter, here's $500. You're a wonderful employee, Mr. Success Valley, I love you. You get $500 this 6 months. Those are discretionary. That's not an issue in what I'm about to talk about. For non-exempt employees, typically your hourly people, if you give them a non-discretionary bonus, you may have to pay overtime on that bonus. So let me give you an example. I have manufacturing workers, and I say to them, you all, if you can get another 100 widgets out this month, I will give you each $1,000. And you're making $15 an hour. And at the end of the month, they made their quota, they got the extra 100 out, and I give them their $1,500. But they worked 25 hours of overtime in that month to create that extra 100 widgets. I now have to take that $500, or whatever I told you I was giving you. Oh, bait and switch. $1,000, and there's a formula for figuring out what the overtime is on that $1,000. So I may end up owing you $1,032. And if I don't pay the $32, that's a form of wages that hasn't been paid. I have this security guard company case. They got $300 longevity bonuses every year. And arguably, we think it was a discretionary bonus, maybe, maybe not, but that probably needed to be grossed up by the amount of overtime they worked during that year. Now, it may be $3 an employee, but you take 4,000 employees over 4 years, and you add penalties and interest and attorney's fees, and it could be a $200,000 issue just for that little thing, maybe. So bonuses have to have bonuses have to have an overtime factor in them if you give non-discretionary bonuses. If every quarter I give you a percentage of income based on the company's production and your personal contribution to it, it probably needs to be grossed up. If I give you a longevity bonus, it probably needs to be grossed up. And there's a little formula for doing it. Easy to figure out, and I can show it to you. And when you pay it, you want your pay stub to show both things. If you just paid a bonus of $1,532, it won't show the bonus on there, and you might not get credit for it if you get sued. Or your pay stub is now inaccurate, and that's a penalty for $100 up to $4,000 per pay period, for 40 pay periods. Okay, more sickening things on the top of page 4. Number 8, employee handbook, related documents, just some quick points there. If you haven't done a handbook update in the last year or two, usually I say to clients, look, you can usually wait a couple years or do a little addendum and you'll slide it in and we'll fix it, in a year or two when you update your handbook. The last 18 months, there has been so many changes. A couple of examples. Social media, huge issue. If I go and say to, what's your name? Well, I'm going to use Tanya because I can read her name. So Tanya comes into my office and says, John, you're the worst boss I've ever had. I cannot work with you. You stink. Tanya, we're not getting along. You're fired. Perfectly legal. But if she goes on her blog or her website or her Facebook and says, this company's got some issues and they don't do this right and they don't do that right, and by the way, John's the worst boss ever, that's probably protected speech under the National Labor Relations Act. And it doesn't matter whether you're union or not. The NLRB and the NLRA, National Labor Relations Board and Act, they cover both union and non-union companies. And California has the same rules. And so, for example, they've been really cracking down on things that have a chilling effect on employees' ability to organize. Employees are entitled to talk about wages, hours, and working conditions. And you can't prevent them from doing that. You can't have a policy that says you can't talk about your pay rate or the bonus you got, because that's wages. And so even they've gone so far now as to say that the at-will disclaimer that you have in your handbook, well, that has a chilling effect on employee organizing, because if Tanya says, well, gee, I guess I'm an at-will employee, I'll never be able to organize and be in a union and get my wages up if that's her goal. Why wouldn't it be her goal? That's a chilling effect. So we have a disclaimer in there now that says nothing in this handbook and nothing about at-will is designed to infringe upon your right to discuss wages, hours, and working conditions, or your rights under Section 7 of the National Labor Relations Act. And we have that in social media section. If you're a manufacturer, for example, if your employee endorses your company, that is covered by an FTC rule. We have a little thing now in our employee handbooks about that. Confidentiality portions of agreements that go too far beyond California law may need to be dialed back. All kinds of little things. And then there's a ton of leave laws, or you screwed up your vacation. Or I see this all the time in sick time policies. You get 5 days a year in sick leave, okay? Is that earned per pay period or per month? Do I just hand you the 5 days on the first day of the year? I have a law firm I represent that on January 1, they give you all your vacation, accrued on January 1. And I said, well, but if I quit on January 2, you have to pay me the 10 days you just gave me. I'm not accruing it. And they go, well, we know. We kind of done it that way forever, and we'll have a revolt if we change it. So we're just going to stick with it. But they would owe me all that vacation that I got on January 1 the next day if I quit. Sort of silly, but that's what they do. So I'm not going to go through it. One thing I will, 8G, progressive discipline. If you're a private sector employer and you're non-union, you want one little paragraph that just basically says, discipline may be oral warning, written warning, suspension, probation, termination. It's within our choice, and the fact that we pick a certain course is within our choice. We can skip stuff, and whatever we do doesn't change your at-will relationship. Simple, without a bunch of steps, that you got to have 2 oral warnings before a written warning, et cetera, because somebody will screw that up. And you won't have the warnings in there that you need before you terminate, and then that person's lawyer is going to say, aha, you had a policy and you didn't follow it. So we don't want to get into progressive discipline. Or handbooks that have, we prohibit unlawful harassment, which is what the California Chamber's Master Handbook says. No, we want to prevent all harassment, whether it's unlawful or not. If I tell Tanya a couple of dirty jokes today, that's not unlawful, but it's inappropriate, and I don't really want that going on in my workplace. But it's not unlawful, and if I only prohibit unlawful conduct, well then as a supervisor, what do? Does she enforce this against me with Tanya? Well, it's not unlawful, and our policy says, well, we only prohibit unlawful. No, we got to change that. Okay, independent contractors. This has been a huge issue, and the feds and the state have been cracking down because they want their taxes. And it's really convenient to say, you know, we'll just call you an independent contractor. We won't take taxes out. You'll be happy. We'll be happy. We don't have to pay payroll taxes or unemployment insurance for you or workers' comp for you. Great. A banking client a couple years ago, we got this guy, he's a courier for us, but he wants to retire and only work 10 hours a week. We want to make him an independent contractor. He's doing the same job he was doing yesterday. He's just doing less hours. He's an employee. Is the person you're calling an independent contractor doing the same work as people right next to him? Is it a salesperson who's exclusive to you and really doesn't have any ability to sell outside somebody else? Are they really an independent rep? No. They're a salesperson. That's your employee. And you need to be careful. If you truly do have an independent contractor and there's a test, there used to be this IRS 20-point test. Now it's lumped into 3 broad categories. The state has 12, a 12-point test. I had a ton of fun last April. I testified as an expert in a jury trial on whether a particular situation in the janitorial world was contractors or not. And when the employer's attorney called me, who I know, I said, you know, I got to tell you, 80% of the time when I read these situations, I conclude that it's not an independent contractor. The company's blown it. And he goes, well, I think we're okay here and you'll see. And they were right. And I thought they were right. And the jury went in our direction and said, no, they're independent contractors. And so they didn't get overtime and meal breaks and some other stuff. But that's rare. If you do have true independent contractors, though, to insulate yourself from liability, get a declaration of medical insurance from them. Get a copy of whatever they use for their personal medical insurance. Because if you've got this little one-off person doing independent contractor work for you and they get hurt while they're doing their work for you and they don't have their own medical insurance, what are they going to do? I'm an employee. I need to be covered by your work comp. And work comp bends over backwards in those situations against the company. So having a little bit of a safeguard that it's more likely that they will go to their own insurance because you now see that they have proof of insurance. And business licenses and business cards. Do they have any employees? Are they using your equipment? Are they on your time? Are you directing their work? Are they doing it at your site? Do you have a rigid schedule that they have to follow? Do you have policies and procedures they have to follow? All these factors go into whether they're independent contractors or not. So be very careful because they're cracking down. And we have a new law in California from about a year ago that says if you mess this up, you can be fined between $5,000 and $25,000 for wrongly classifying someone as an independent contractor.
And where do we find that 12-point test or 20?
It's in my head. Send me an email and I'll send it to you. Okay? The 20-point test, if you go online and go IRS independent contractor test, you'll find all kinds of stuff. And if you go online and go California State independent contractor test, it's an 11-point test plus a case that has the 12th. Who controls the means of production is kind of the number one deal. Okay, and you don't have to satisfy all of them or 90% of them. There's no bright line test. Some are more important than others. All right, I'm going to move on. Number 10, how many of you have commission employees of some sort? All right, this is kind of a big deal because we have a new law that says all employees must have their commission agreements in writing signed by the employee. And I just did a whole cheat sheet on commission agreements. If you're interested, I'll send it to you because they get screwed up all the time. And some highlights. Net commissions. Well, what's net? How is that defined? What if you've got a dispute with another person about who gets that commission? Who's got the power to split it up? What about what I call tail commissions? Commissions are in the pipeline and they get fired or they quit. When do they earn their commission? Is it on shipment? Is it on invoicing? Is it on signing? Is it on collection of the money? And what happens if it's in the pipeline and they've done everything they can do to get that commission, but they're gone now? Do you have to pay it? Well, if your contract is at all ambiguous, the Labor Commission says you have to pay. If it's very clear and it's not unconscionable, it's not unfair, like they quit or they got fired for some really bad thing, they don't get commissions that don't come in after they leave. But if you terminate them for sort of garden variety reasons, they probably do get commissions that come in over a reasonable period of time. And you have to be very careful to define all of that. And the more specific you are, the better chance you will have of being able to deny them future commissions after they leave. And it gets very tricky in things like insurance where there's residuals or life insurance policies. I got one right now with a guy who's claiming he's got $48 million of residual policy that he was wrongfully fired. Well, he wasn't even an employee, which is another issue. But all those things can add up. And so be careful about not having a commission agreement that's very clear. Also, one little thing, this comes up every once in a while. I have a guy right now who is a real issue, and he's got $700,000 claim for vacation as an outside salesperson. And the company said, we don't pay vacation to salespeople. And he goes, well, where does it say that? Where am I excluded under your policy? And he may have a claim. I don't think so, but he may. And because with outside salespeople, you can't really track what they're doing, and they're getting commissions in even when they're not working, you may want to exclude them from your vacation policy. And you have the right, except for medical and for 401k, retirement stuff, you have the complete right to exclude categories of employees from vacation and sick time and holidays, whether they're full-time or part-time, or outside sales or inside or admin or field. You can restrict all that and do it differently by different departments or groups, except there are restrictions in medical and retirement. And I'm not the expert on some of those things.
Can you make their vacation based on their base pay only and not on their commission?
Absolutely. Yeah, that's a great point. You know, when you go out, I don't want to be paying you on your $10,000 a month commission. I want to pay you on your $4,000 base. Perfectly acceptable, but lay that out just for that reason. Okay, how about let's go on to employment agreements. Depending on the level of employee, you may want to do this. Good cause provisions or not. Depending on how senior and how much leverage they have, you may not be able to get away with an at-will clause. No. I'm coming in as the VP of operations making $250,000 a year. You got to have some cause to get rid of me. Okay, well, let's figure out what kind of cause that could be. Certainly malfeasance, or they get convicted of certain felony, or stealing from the company, or habitual failure to follow directions with notice and an opportunity to cure. Those may be good cause. But a lot of times I'll see you're an at-will employee in paragraph 2, and then 6 paragraphs later, there's all this elaborate stuff about the term. You got a 2-year term, but you're an at-will employee. Well, how can that be? It's one or the other. Or we can only have good cause for termination, but you're at will. That's not consistent. So make sure that those kinds of things are consistent in the agreement. What else? Profit sharing. Sorry, I'm going to skip number 12. Although you do have employees in stock plans, stock option plans, I won't skip it, just real briefly. Be clear who's in the plan, when it vests, what plan documents control, and always have a caveat. When you're describing something kind of generally in an offer letter or in an employee handbook, that if there's any inconsistency between the employee's agreement and the handbook, the agreement controls. If there's any inconsistency between the medical plan documents and what we said in the handbook, the plan controls. Same thing with retirement documents. You don't want to say it wrong in here and suddenly be obligated. One little quick tip for next year with the new healthcare law. A lot of employers have, you qualify for medical after 90 days. And that usually is done wrong. It's the first day of the month after 90 days. How many of you have that in your policy? Okay. Well, with the new healthcare law coming in, it's 90 days. There's no first day of the month after 90, it's 90. So now you're going to have to do 60, or the first day after 60, or exactly on 90, which is kind of a hassle because it's not in the first of the month. So think about how you're going to deal with that issue. Okay. Let's talk about 13, disability and reasonable accommodation. How much time we got? We got about 5 minutes? Okay, well, I got another presentation at 10. And if you got to go, go, and I'll spend a few more minutes, but I will not run over by very much. And if you got to run, run.
If you would, is take questions on things that might be on the agenda.
Okay.
If we're short of time, so people would have a chance to
Well, you know what? We might make it. I've only got 2 more topics. But I will take questions. And if anybody has a question right now, fire away. But let's get through disability accommodation. I'll spend just a brief moment on that. This is my least favorite area of the law to deal with and defend. I have 2 cases right now that should be winners, and who knows? I have a gal who had migraine headaches. She was a customer service person who needed to have continuity with a set number of customers. And they accommodated her, they met with her, they did the interactive dialogue where they met, they went over job descriptions and how they could modify things and make things easier, et cetera, et cetera, et cetera. And this went on for months. And she kept basically saying, look, if I can't come in, I can't come in. And they couldn't accommodate that. And so finally they said goodbye. Well, now we've got maybe a pending lawsuit. We wrote back a very strong letter saying here's why we win. And we did the reasonable accommodation. We did the interactive dialogue. We did it repeatedly. We tried multiple things, all of which you need to do. Paperwork documenting this effort when someone says, I have a disability or I have a problem. You need to step in and work with them and document all the meetings and the things that you try. And you can't just pick one thing. You may have to try something else. You can pick the thing you want if it does work. You don't have to pick what they want. But it's a very difficult area of the law because now I got this woman who has migraine headaches, is going to get the sympathy vote. They don't have arbitration, and it's going to be a problem. Actually, that one does have arbitration. I have another one with a woman who's very good. She processed orders for a manufacturer. Tens of thousands of dollars per order, some in the 6-figure range. And she was great until she had a seizure. And then she went on seizure medication, and now she became a terrible employee. Mistakes costing them literally hundreds of thousands of dollars in messed up orders. And they created a system of checks and balances to check her work. They reduced the kinds of orders she was working on so the hits wouldn't be so big. And they did lots of things to try to work with her and accommodate this issue. Now, they weren't required to reduce their quantities. Let's say you had someone who had to turn out 20 widgets a month, and because of their disability could only do 15. You're not required to drop their quota to 15. You're required to see if you can accommodate them in a way that gets them up to 20. And in her case, finally they just said, look, you're costing us $400,000 or $500,000 now. We've done everything we can to make your load easier, and it's still not working. Goodbye. And I got a letter from her attorney the other day after we wrote back a really strong letter and months went by. I thought we were rid of him. And he's back saying, I'm ready to go. And he doesn't like our arbitration agreement. The client wasn't a client at the time. It's not well written, and it does maybe have a flaw in it that may be fatal. And so we may be stuck going to court.
Now, with the migraine thing, are they required to bring in a doctor's note with restrictions of what that person can do?
Yes, you're always entitled to a doctor's note.
Okay.
And if they come back with restrictions, one, you could have them go to your own doctor if for some reason you don't believe them. You can send them for fitness for duty exam, something coming off. By the way, if you give someone FMLA notice, you've got 50 employees, if you are always going to have them do a fitness for duty before they are allowed back in the workplace, you have to give them notice at the beginning when you send them the FMLA notice that you will be having to do a fitness for duty exam when you come back. Any medical exam required at the end has to be given notice at the beginning under some amendments to the FMLA. By the way, quick little tip that we just discovered, December 28th, well, we discovered it last month, but December 28th, the state came up with some new laws about pregnancy disability and your obligation to pay medical premiums. Remember, a year and a half ago, they changed the law. 4 months of pregnancy disability, you got to pay the premium. You had to do it under FMLA anyway. But now, when they go out for the 12 weeks of baby bonding after that, you got to pay the premiums now during that time too, which you didn't used to have to do. So big change. Okay, so the accommodation issues are just brutal. Do not try that. Train your managers that if they have even the hint of a problem with an employee, get it to HR and let them start dealing with the experts because it can be very difficult. And then when someone finishes their FMLA, their 12 weeks is over, and hey, we don't have to hold your job anymore. But you still have to look at reasonable accommodation because now the ADA, Americans with Disabilities Act, or the state law kick in. And after 12 weeks, you still have to say, could we reasonably accommodate time off? So it doesn't just end when the 12 weeks ends. Be careful about that. All right, last thing, termination, discipline, layoff. We have this concept of at will. Everybody's an at-will employee. I can terminate you at any time with or without cause. Well, that's great, except that at will is not all that valuable because it is not a defense if an employee says, you fired me for a discriminatory reason, or I was harassed, I had to quit, or you retaliated against me for complaining about working conditions. You cannot say, well, you were at will, I don't need reasons. Not appropriate. And even brand new employees, you need to treat every employee as if they're going to sue you for discrimination or one of those categories. So I had a similar case. You have the new receptionist, but she turns out to be the receptionist from hell. And after a week, she's a disaster, and you say, hey, if she's not at will, who is? Goodbye, Tanya. Sorry, it's not working out. Just a hypothetical. And she's dropping calls. She's rude to customers. She doesn't know how to use the board. She's a mess. And she's gone. And 2 weeks later, we get the letter from her attorney saying, my client was pregnant, and she told a coworker. And you heard about it up at management, and you didn't want a pregnant receptionist. Or you didn't want her on our medical, and that's why you fired her. And we say, no, we fired her because she was horrible. And they say, well, where's the documentation? Did you tell her that? Did you put that in writing? Did you give her a chance to fix it? Did you do anything to suggest that this was an issue before you fired her? Now, you're going to win that case as an employer, but because you have no documentation and you can't rely on at will, you have to prove that you had good cause for the termination. Well, now you've got to spend the $150,000 in legal fees to defend that case. It would have been a lot better to say, Tanya, you're not cut, and I wouldn't give her necessarily another chance, but I would document. And there's always, sometimes people say, well, my attorney said not to write anything down. That's nonsense. Paper is your friend. And so I'm going to do 2 documents. Memo to the file with all the bad things she was doing and all the problems in great detail, and here's all the drop calls, and here's the emails from clients. And I'm going to give her a memo, nicer and shorter, that says, here's the issues we were having with your performance. It's just not working out. I'm sorry, it's not a good fit. Goodbye. And by the way, you're an at-will employee, but we wanted you to have the reasons for the termination. So now we have clear documentation of exactly why we let her go. And when she goes to the plaintiff's attorney and they see all that documentation, that may be a deterrent. Now what happens, and I've had a couple of these now, she goes to let's say she's a 5-year employee and having issues, and she thinks she's been wrongfully terminated, goes to the attorney, and she looks at her case and says, you got all these documents here that says you really were a pretty crummy employee, Tanya, just a hypothetical. And so I don't see a wrongful termination claim. But tell me how you were paid. Oh, I got a salary. Well, what did you do? Oh, well, did you work overtime? Yeah, but I didn't get paid because I was on salary. And what about meals and rest breaks? And now her wrongful termination claim, which is no good, turns into a wage and hour claim. All because the attorney has been trained now to ask the right questions. And that's where these cases come up. And then there's 6 other people that does what she does, and they're all on salary, and they're happy. But then they find out that Tanya just got $32,000 from you, and they go, well, I really like you, Maria, but I want my money too. And now you multiply that by 6, and you got a big problem.
When you're putting notes in their file, do you need to let them?
You're not required to if you're non-union, but it's a good idea to issue them a memo and have them sign it. If they don't want to sign it, don't sweat it. One last point. What I call the catch-up memo. This happens all the time. I get the call from the HR manager. John, the manager's pressuring me. They said this employee for the last 9 months has been horrible. They've been there 5 years. They've been doing a terrible job for 9 months. They want him fired. And I said, well, did they document anything during the 9 months? No, nothing by itself was really warranted, or they didn't have time, or they didn't want the conflict of having to deal with a mad Tanya for a bad memo. And so there's no paper. Well, what about annual reviews? Yeah, we don't really have any annual reviews either. Or they're all really pretty good because nobody likes conflict. So they give them, basically okay grades. Or it was a former supervisor who was a real easy grader. So what do we do? And they fall into they're 65 years old, they just came off surgery, they're the one person different ethnically from the other people in their group, and we're going to fire them with no paper. No, we're not. And we don't have EPLI and we don't have arbitration. So we're going to do what we call a catch-up memo, which is referenced somewhere in here. Yeah, 14D. The catch-up memo basically consists of, Tanya, today you did a really bad thing consisting of the following. And that is consistent with the pattern of behavior over the last 9 months consisting of the following. And now you put the list together. And it's all in one place now. It's not perfect, but it's really good because in a year, if she sues you, you've got this memo that describes all this bad conduct and it's all in one place and it's documented. Juries and judges and attorneys believe paper. And so now we're going to put her on probation. Here's all the things you've done wrong. You got a month or 2 or 3 to straighten it out. And then the probationary memo has certain bells and whistles in it. This is what you're doing wrong, ABC. Here's what we want done right, ABC. One key thing that I like to do in probations is, Tanya, by Monday, I'd like you to provide me a memo with how you think you can do better and maybe make this work for us and you. And what happens on Monday? Oh, I didn't really get to it. Okay, well, let's have it by Friday. It doesn't happen. Well, now on Friday, we're feeling pretty good, like she really doesn't care and blowing us off. And if we go to terminate her at some point in that process, we can show one other piece of, hey, she blew us off. It really helps to have them be participating in the process. And it's not a 90 days, and Tanya, you get 89 days to have a little vacation here. Buzzwords. If we don't see immediate and sustained improvement, we may have to end this probation early because you're not making any progress. And then last point, when they finish that probation, send them a memo confirming it. Hey, you did a good job, you got off probation, but this can't happen again or we're not going to do probation again. Because a lot of times I'll get the call 7 months later. Tanya did great for 3 months, but she couldn't sustain it. She's doing the same old stuff again. You know, been there, right? Can I fire her? Well, yes, you can fire her, but wouldn't it have been nice to have a memo setting the expectation that if this happens again, you did good, but if it happens again, we're letting you go. I'd feel much better about that termination with having that other piece of paper in the file. So, paper is your friend, and then you do all the things right, turn the page, and you go down to page 7, and you hold your breath because you still don't know what's going to happen. So there you go. That's probably enough for today. Indigestion, not my problem, sorry. If you have questions or need help, let me know, and I'll stick around for questions for just a couple minutes because I do have to be somewhere at 10, but it's just down the street. That's it. Thank you. All right, we got one question. If you got to go, go will not hurt my feelings. Yes, sir.